Hello and welcome to this latest video member resource from ACT, the App Association. This is part of our series of videos where we're trying to help our members with the questions that are bothering them and their businesses. And today we are going to talk about IP law, because when we speak to our members, it's one of the issues that comes up a lot. How do they patent their inventions? How do they access patent technologies? And particularly where it relates to small and micro businesses, exactly what they should be doing to make sure that they are in the most secure position possible with their IP. I'm joined today by Pete Sadler, who is a partner and patent attorney at Reddie and Grosse law firm. Pete, well, thanks for joining us today.
Thank you very much for having me, Stephen. It's a pleasure to be here. It's been great learning about the ACT and the work that you guys have been doing with SMEs. It's genuinely a pleasure to be here and talking with you.
Oh, you too. And as you alluded to there, just to sort of frame this conversation, our members are either very, very, very small or SME tech businesses, and they either make apps and software. Some of them make connected devices as part of the IoT space. And I think they share that thing that most SME businesses have, which is they are very, very busy, often with limited resources. And, the question of IP, when you're an innovative business, IP is, it's the lifeblood of what you do, protecting your own IP and also accessing other people's IP so you can innovate. So yeah, the purpose of this conversation is really to help those businesses have a sort of a quick and easy accessible guide so they can keep on doing what they're doing, which is making brilliant products and innovating.
Yeah, absolutely. And the small companies and SMEs often have different needs and need to think about their IP strategy in a different way to sort of large multinational companies that might have a different aims and a more a bigger budget, shall we say. So that there are often considerations specific to small companies and SMEs.
Thanks, Pete. So I thought we'd start with something that would be useful to our listeners and to me, to be completely honest with you, which is an overview of the IP and patent process. If you wouldn't mind giving us a rundown of what that landscape looks like.
Sure. So I'll start with some general points about IP, and then we'll delve more into the patent process, because it's a bit like when people talk about IP, I don't know, it's a bit like doing up your house and trying to work out what people you need to do what, because you need electricians, plumbers, plasterers, and so on, and they have different functions and different roles. So broadly, IP, there are lots of different rights out there that are available for people to acquire and use. So we've got patents we've mentioned, and we'll talk about those in more detail. There's also things like trademarks, and there's design right and copyright and others, actually. So very briefly, trademarks, for example, trademarks are anything that identifies and distinguishes someone's products or services from those of others. In a competitive marketplace, which a lot of SMEs and small businesses find themselves in, adopting a distinctive trademark is essential to ensure that your product or service stands out from the crowd. At the same time, you do acquire some rights by using a trademark, but normally it's better to actually register your trademark through the Intellectual Property Office. So as I said, as you introduced at the start, I'm a patent attorney. I specialize in patents, but Reddie and Grosse and other IP firms will have trademark attorneys as well, who can advise on the best way forward for registering your trademark and protecting that. There's also designs. Designs relate to the appearance of a product. In general, design rights allow you to prevent competitors from adopting the same design. And when I'm talking about design, that's an aesthetic thing. It's the way that something looks due to the shape or the coloring or the material that's been used to make it. And designs don't provide protection for For technical function for the product itself, it's the way it looks. Technical function is the realm of patents, and patents protect technical innovation. They allow you to stop others from dealing with the invention, making it, using it, selling it, etc. So it's important to remember that a patent is a negative right. It's the right to stop others from doing something. It doesn't give you the right to do anything other than stop others. So having a patent doesn't guarantee that you are free to yourself exploit your invention. And there are other considerations that we'll come on to talk about later about freedom to operate and other people's patents. But patents are a very strong right compared to other forms of IP, because they can protect an inventive concept, an invention, without being limited to the particular embodiment, the particular way of doing it that the inventor has come up with. So it allows you to potentially get very broad protection that would stop other people from implementing the invention, even if they came up with a slightly different way of doing it. The patent could still cover that, and so it gives quite broad protection for a market share.
And I think, so I was going to say, I think that's a really important thing for our members, because a lot of them are developing products. And when you do develop products, they go through that development process goes through a life cycle. And what you end up with will look very, very different from the version 1 of the product you developed. So I think that's an interesting point that, your patent, as I understood what you've said there, covers almost the innovative concept that you've come up with, and you don't have to do it again every time you do a version 2, version 3, version 4 of the same product, as long as it's doing the same job.
Yeah, absolutely, and that is very common. As you say, products have a design life cycle before you get anywhere near marketing it, and you need to take that into account when you draft your patent application. It's one of the reasons why it's a very good idea to get a patent attorney involved in the drafting of the patent application. It's something that the system is, it is possible for people to do it themselves. It's entirely possible for someone to draft a patent application and file it. It's just they're very specific documents, and if you don't think about all the possibilities of how something might develop and trying to cover it in as broad a way as possible, the patent, the problem you get with individuals and trying to do it themselves is that they might get a patent. Actually, it just might not be commercially very useful, because it would be too narrow and likely quite easy for someone to design around. So getting that advice at an early stage from a patent attorney can make all the difference between a patent that is commercially valuable and a patent that is not commercially valuable.
I think that's interesting. I'm going to be honest with you. A lot of my patent knowledge comes from Dragon's Den, the BBC show. And it's something that you see on there quite regularly, where people come onto it with their invention and go, oh, we've got it patented, we're protected. And the dragons take a look at it and go, oh, actually, you're not protected here in the way that you think you are. And that's obviously bad for their business. And then I've spoken to other companies that are members of ACT who have had the opposite problem, where they spent quite a lot of time and effort and resource chasing a patent, and it turned out they were chasing the wrong protection for the stage their business was at. So again, yeah, I think you're absolutely right. Seeking advice helps you, helps you get the right patent at the right time to meet your business needs. And it's very hard to understand that if it's something you're doing on your own and you don't have that background.
Yeah, and you absolutely need to consider, it's a great point about are you seeking the right protection? Because you want to focus on what is going to be commercially valuable, and that often involves spending the effort on perhaps the crown jewels, the really important features, and perhaps diverting money away from trying to protect ancillary features, and sometimes people get a little bit caught up on what is the right thing to protect. If I thought maybe we could step through the patent process, and I can explain the various bits along the way where you might consider this kind of thing. I mean, the basic process, the really short story is that you file your patent application describing your invention with the patent office. An examiner at the patent office examines it to check that it meets the legal requirements for patentability, for a patent to be granted. And when the patent examiner is satisfied that it does, they grant a patent. Simple as that. However, in practice, there's a lot more to it, and starting way before you even file your patent application. I mean, the first step is to normally identify the inventions. It sounds obvious, but actually it's not always so easy. And inventors, particularly if they haven't been through the process before, or have perhaps only done it a few times, and especially in the software space, people tend to, they've come up with a product. They've come up with a software product, an app or a program that's going to do something. But products are not inventions. And so the first step is normally what I'd call an invention harvesting session, where you get together round the table or via Zoom or whatever, and you get deep into what it is that they're doing. What is the software? Let's talk about software for example. What is the software? What's it doing? How's it doing it? What's important about it? What features could you take away and it would still do it in a way that would be acceptable? What features might you want to add? What other things might you want it to do in the future? And you often, it's very rare that I sit down with inventors and you come out with one invention. Normally there are several. And what you're looking for is patent law really considers inventions to be solutions to problems. That's a good way of looking at it. And normally when coming up with a product, coming up with a piece of software or whatever, inventors have solved more than one problem. And that's your starting point, is this list of inventions that you could potentially take to the next step and look at filing patent applications for. And you look at those, and which ones of those are the commercially important ones? Which ones of those are the ones that you would lose sleep at night if you thought your competitors would be able to do, and would be able to take market share away from you? So you've got this list. The next step is to consider whether which of those inventions might actually be patentable. We haven't talked about what the actual requirements are for something to be patentable, so perhaps we just step through those quickly. Really, there's really two requirements for most inventions. For software inventions, there's kind of three. Your invention needs to be new, so it cannot have been disclosed to the public before you file your patent application in any way, as any form. So it could be a disclosure on a forum on the internet, it could be on Reddit, it could be on GitHub or something like that. It could be a book in a library, it could be someone having a conversation with someone else. Any form of disclosure is potentially enough to destroy what we call the novelty, the newness of your invention. So rule number one is keep it secret before you file your patent application. If you're going to discuss it with someone, then you need a non-disclosure agreement in place of some kind.
I was going to ask you a question there, because I think I didn't know that. And I think one of the things that's quite interesting is, particularly on the app and software developer side, it is a very community-based endeavor. And there are a lot of, online forums and things where app developers meet and discuss problems that they're facing with their software. And it's that they're often talking about specific issues with the code. Does those specific discussions count towards what you were saying, or is it more a disclosure of what the product is as a whole that's an issue?
The answer is, unfortunately, it depends on the situation. It can do.
Okay.
I mean, if it's just someone is looking to find a particular technique to do something that happens to be part of the broader part of the invention, then it's probably all right if they're not disclosing the core features of the invention. What's important is that they don't give what's called an enabling disclosure of the invention, which means that you provide enough information for someone that works in the field to go away and put the invention into practice. What's probably best is to just seek a quick opinion from a patent attorney on whether doing that would be a problem or not. Software, as you say, is collaborative. Software engineers, by their nature, like to collaborate and like to tell people what they're working on and what they're doing. Unfortunately, the patent system is not really compatible with that, so you just need to be careful.
Thank you.
So yeah, newness, novelty, we've covered that. Inventive step is the next thing. So what you're doing needs to be new, and what's new about what you're doing needs to be inventive over what's been done before and what's been published before. People hear the need for an inventive step and are sometimes put off because they think, oh, I need to have come up with the next theory of relativity or a paradigm shift that means otherwise I'm just not going to get a patent. And that is not true. It's the test is whether it's something that would be obvious for the skilled person working in that field of technology to do, bearing in mind that they have access to what we call the common general knowledge, what would normally be known by someone working in that field. But that skilled person, that person that is used to assess whether something is inventive or not, has no imagination. They have no creative ability. So it's a legal fiction, but it's intended to enable you to protect things, provided there's some kind of creativity, some kind of scintilla of invention there. It doesn't have to be a paradigm shift. So most patents are granted for relatively modest improvements on existing technology. So it's something to, again, not be put off by. Speak to a patent attorney, speak to someone like me, and we can give you a view on that. Now, the other criteria that's particularly relevant to software inventions is that there are certain exclusions from patentability, certain things that patent law says you can't protect. One of which is software, but we're going to, I think, come on later to talk in more detail about why that's not actually the case, and just because your invention happens to be made in software does not mean that you can't get a patent for it. So those are the basic requirements of whether something's patentable or not. So you've got your list, and you've looked at whether each one may or may not be protectable. There's also consideration as to whether the invention would also be detectable. I could get a patent for something, but if I had no idea whether my competitor was implementing it or not, and I couldn't work that out, then there's a consideration as to whether that's a valuable patent or not. And that needs to be thrown into the mix as well. And that will sometimes, especially when your budget is limited, that might inform the decision as to whether you decide to protect it or not. Because if there's no chance that you could detect an infringement, then the patent you're not really going to be able to use it to stop people from doing something. Now, that's not always the case, and there are sometimes good reasons to file for something that you might have difficulty detecting. But nevertheless, it's something. It's a factor to bear in mind. If possible, you want to be protecting what is closest to the end user. It's closest to what the end user will be seeing and interacting with and doing in the case of software. The other consideration, of course, is if what you're doing would not be detectable, if the invention would not be detectable, then is it possible for you to keep it secret? Because part of the patent agreement, part of the reason that the government gives out patents in the first place, is that in return for disclosing your invention to the public, patent applications are published. So in return for that publication, which benefits society because the advancement in technology is provided and people can see it, and so that advances the technological understanding of society, and so there's benefits there, and people can take that and maybe develop it further. In return for that, the state gives the inventor a monopoly. So as part of the patent bargain, there's this disclosure requirement. Well, that means you have to tell people how to do it. If you can avoid doing that, then perhaps that's better. Protect it as what's called a trade secret, and commercially that might be more useful. I mean, SMEs and small companies often like that because it doesn't cost as much, frankly.
So would I guess a famous example of that, would that be kind of like, the recipe for Coca-Cola, for example, which is, I don't think it's a secret recipe and it's a trade secret. Is that why you would do something like that? Because actually you don't want to tell everyone what goes into your product, and so you just keep it secret, and people can guess and come up with rivals. Like, I think that's what happened with Pepsi, but actually fundamentally you're just keeping it secret.
Yeah, absolutely. It's if the recipe for Coke were patentable, yes, they could have taken that route, and they could have got 20 years of patent protection for that, but that would have run out and other people could have come along and copied it, and they would have had to have given away the recipe and how they make it. So instead they limited access to the information as to the full recipe, and can protect it therefore as a trade secret.
Brilliant. And I think one of the points you touched on earlier as well relates to that SME perspective, and whether or not discoverability is something that is possible, because there's a famous maker of household appliances who is very well known for hiring lots of lawyers and technicians to rip apart other competitors' products to see if there's been any IP infringement. And if you're a certain size business, you can do that. And that means the discoverability piece of your patent law is, it's something you can back up. But if you're an SME or a micro business, you probably don't have the time and resources to be doing that sort of thing. So you have to look at the cost risk benefit there for a business of your size.
Yes. At the same time, you have to consider that patents last for 20 years, which is quite a long time. And you don't know where you're going to be in the future. And you don't know perhaps what you might have an exit strategy that might involve you selling to one of those larger companies that has the resources. So yeah, it's something that you need to consider, and with the point in mind that patents can last for quite a long time, and therefore there might come a point in the future where you would be able to spend the time detecting this kind of thing.
And sorry, there's one of the, I'm going very off what our questions were, but I'm interested in this. There's one other term I wanted to ask you about, and that is, this idea of patent pending. So you've got an invention, you've applied to the patent process, my understanding of patent pending is that you're protected while that process is going through. Is that correct?
Yeah, so there's this concept of marking your product and saying yes whether you're patented or patent pending. The protection from having a patent, you can't actually sue someone or enforce your patent until the patent is granted.
Mm-hmm.
So that's the point at which you can actually start enforcing it against people. But the concept of patent pending, once your patent application is published, you start to accrue rights, such that if someone were infringing the claims of your patent application, and they also infringe the claims of the patent as it's granted, you can backdate your damages that you're seeking from them for infringement to the point at which your patent application is published. So you do accrue some rights for a pending patent application. And at the same time, also, once you file your patent application, that is staking you're planting your flag as to how your patent application is assessed for whether it's new and inventive. So there's also the benefit of having your filing date, because that's the point at which you'll be assessed for whether your patent meets the patentability criteria. So there's a few things in play as to when you're marking something. What is important is that you don't mark something as patented when it's not patented, because that is actually an offence. You don't want to do that. You can get in legal trouble for doing that. So you can mark something as patent pending whilst it's pending before it's granted. When it's granted, you can mark it as patented.
No, thank you. And no, that's really helpful. And I think one of the things you touched on earlier is software. And actually, one of the questions I get asked occasionally is, can you patent software? What's the process for doing that? We've got members who do things with technologies like artificial intelligence and how that side of it works. So yeah, could you delve into software patenting a bit more, please?
Yeah, absolutely. So I touched on it earlier that the software implemented inventions, there's that extra requirement. Is it excluded or not? Because patent law in the UK and Europe, there are certain things that are just not considered to be inventions. They're not patentable inventions. So that includes things like discoveries, scientific theories, aesthetic creations, business methods, presentations of information, and programs for computers. So the law says that you cannot patent those. The law then says you can't patent them to the extent that the invention relates to that stuff as such. And it's this wording, this as such wording, that creates this grey area that patent attorneys like me spend a lot of time in and thinking about and arguing before the Patent Office. So just because an invention happens to be implemented as a computer program doesn't mean that it's necessarily excluded. You have to think about what the invention is actually doing. And often this will be, you'll consider it as what problem is the invention solving. You look at what's been done before, you look at what the invention is, and you think, well, what's different? What is that solving? What problem is it solving? I like to give an example to just plant the extremes of where the what's patentable and what's not lies. And the example I give is a washing machine versus some kind of number calculator. A washing machine these days has probably more processing power than what was used to send man to the moon. They're computers. You can run programs on them. If I came to you and said, I have a program that I could load onto your washing machine and when it runs, it will get your clothes just as clean, but it will use half as much water. Then I think it's quite easy to see that that software is having a real-world beneficial effect on a technical system, on the washing machine. It's having this real-world effect. It's using less water. It's solving a problem. If I were to compare that to a software program that runs on any computer, doesn't matter what, and it calculates a number, calculates pi, or it calculates the square root of 2, it's not having any particular effect outside the computer, and it is purely a computer program, and that wouldn't be patentable because it's not actually doing anything in the outside world, and it's just a software, a piece of software running on a computer, not having any other impact. So what you end up with is really two main ways of getting a patent for your software, to avoid this exclusion of it being implemented in computer as a computer program. One is the application of your software to a particular field of technology, to a particular problem. So if the program has an effect on how some other technology functions, then the software might be patentable. If it's used in a control system for controlling a process, i.e. the washing machine example, or industrial machinery, or wind turbines, or things like that, physical machinery, then the software is normally going to be patentable. Essentially, it's having a real-world effect in a particular field of technology. The other area that gets slightly more grey in some ways, but the other area is if your software is particularly adapted to run on particular hardware, and it takes into account the technical considerations of that hardware, then that is also based on technical considerations and therefore might be patentable. So it's those two things. Is your software being applied to an area of technology and therefore having a useful technical effect in the real world? And that covers things like image processing and control of industrial machinery, or any machinery. Or is your software solving a particular internal problem with the computer, taking into account how the computer actually works on a technical level, and then you might be able to protect it.
That's really useful, and I guess, and I think this is a rabbit hole that we could fall quite deep down. So if it is possible, just to cover this very briefly, as I mentioned earlier, a few of our members work with artificial intelligence as the cornerstone of their product. So what are the rules about that, how that works?
Yeah, in principle, the Patent Office says it's not any different to any other type of invention. They like to make that clear, but it's a good example because AI is maths. Artificial intelligence is maths, and a lot of the maths has been around for quite a long time. So a pure artificial intelligence program, I don't know, a convolutional neural network or some type of machine learning is going to be probably excluded as being a mathematical method, or if you implement it as a computer program, just as a computer program. As soon as you apply it to an area of technology, so use of AI in image processing, or in learning how to better control an industrial machine or an industrial process to make it better, then you might be able to protect aspects of the AI. Also, if your AI is designed in a particular way so that it runs on the hardware in a better way, taking into account the technical, the underlying technical function of the hardware. So say your AI runs better on a computer because it takes into account how the memory fetches work, or it does something along those lines, then that would potentially be protectable. It also goes back to the considerations we were talking about to do with detectability. Because if, say, what's clever about your artificial intelligence is how it's trained, well, that's great. You might actually be able to protect that if it results in a better AI for performing a particular function. But the general public wouldn't see how you train your AI, and it would be very difficult to work out actually from the actual program the actual computer program that is implementing the trained artificial intelligence system. It would be difficult to go from that back to the training and the training data and working out how that was done. Not impossible in some situations, but generally difficult. So it again brings in this consideration as to where is the value, and can you protect what's valuable about it?
So the next question, I suppose, is that software specifically, and a lot of our members as well make hardware. They make things like, it might be a Bluetooth sensor, it might be a module to make something, a smart device and connect to the internet. So I suppose, what's the same and what's different when it comes to patents around physical, hardware products rather than software?
Yeah, good question. In theory, there's not. You still have to do the same things. You have to describe in your patent application how the invention, or an embodiment at least of the invention, would work. With hardware, you're not worried really about the patentability issue, the exclusion as to whether it's software or a mathematical method and so on, because that doesn't apply to hardware. It's a thing, and that's easy to see and to describe and claim. The difference is really that when you're protecting software, you need to think harder about that question. What is it that you're protecting, and what is it about that is solving a technical problem that means that your software is not excluded from patentability? So it's just that extra consideration. In terms of what you protect as well, with hardware, with a chip, for example, you can protect the chip itself. You could protect the chip within another piece of hardware. It might be a chip that goes within a phone, or if it's an Internet of Things, it might be related invention. It might be, I don't know, a toaster with the chip in it, fridge with the chip in it, that kind of thing. So you want to think around what's the smallest thing that you could protect, and what's the biggest thing that you could protect, and structure your application around that. With software, you want to normally look at how is it actually going to be implemented, where is it going to be implemented, because software is normally a distributed system. You've normally got a client somewhere that might be anywhere, and you've got a server that also might be anywhere, and they're not necessarily in the same country. So you want to carefully consider what the invention is doing and look at whether you can protect what is going on at the user end, if possible. Because if that's the bit, if you can protect that on its own, separate from what's going on at the server end, then you have an easier time of enforcing your patent, because it's easier to tell if someone's infringing it or not.
And I suppose one final question on that front is, a lot of our members do both. So they make a widget that is controlled or sends data to an app or some software. So would that, from a patenting perspective, would that innovation be one thing, or would you do it separately?
it would depend case by case, because it depends on whether the software function is tied to the hardware function. If the software is providing additional functionality to the hardware, but the hardware would operate on its own, then you might try and protect both separately. If actually, and it depends on what the inventor's done. I mean, have they actually designed a new widget, or have they taken an existing widget and changed the software in that so that it does something new? If it's the former, then you'd probably look to protect both. If it's the latter, then you're probably going to be limited to protecting just the software, or the software plus the widget.
Got you. Thank you. No, that's really useful, because I think that applies to quite a few of our members. And no, that's really helpful. Thank you. So the next question we're going to move on to is, hopefully there'll be a few companies who've been listening to this and go, that sounds relevant for me. That sounds like something that, would impact my business. So what are the essential first steps that they should take? What's, so I guess the basics of IP strategy for a small or micro business?
Yeah, good question. I think there's two broad categories. There's what you've got, and there's what other people have got. So what you've got, it's important to get a grip on that, and sit down with the technical team, with a patent attorney as well, if you want to have an invention harvesting session, get a list together of all the potential inventions that you've got. Because if you know about it, you can make informed decisions about what you do with them. There's a thing called an IP audit, which is effectively that, having the invention harvesting session and looking at patents and other forms of IP as well, looking at trademarks and design potentially too. And there is actually funding available through the UK government. Innovate UK Edge have an IP audit scheme where you can get most of the budget for carrying out an IP audit. I think the company has to pay about £500 towards it, and the government foots the rest of the bill, which is really very useful. Actually, it's a great first step for companies that haven't done it before, because you do end up with this report that serves many functions. It allows you to make decisions about what you're going to do with your IP. It also is the kind of thing that investors like to see, because if investors are going to invest, they want to be comfortable that the steps have been taken to protect their IP. An IP audit lets you put an IP strategy in place. So that's a great first step. And the other thing,
sorry, my understanding of the way that works is that the business needs to partner with a legal person to make that possible. Is that right?
Yeah, you need an advisor that can do the IP audit. So that's the government will pay the advisor's fee, or most of it.
Right, and I just wanted to get that in there just to reassure our members that the funding's there, but it doesn't mean they have to do the audit themselves. It's it's expert led. It's done by people like yourself who know exactly what they're looking for.
Exactly, we've done many of them with through Innovate UK Edge, and it's something that advisors like us would be well familiar with, and well able to come and help them out with it. The other thing to consider that's important to get right first time, and at the start, is ownership. Who owns the IP? Because often SMEs and small companies will think that they own things that they don't actually own. For patents, the owner of the right to be granted a patent for an invention is, in first instance, the inventor. If you've been working with an outside collaborator, or your mate, or a family member, as is often the case, I've had examples of all of these, then you need to get in place an idea of who the owner is. You need to work that out. If it's an employee that has created the invention, then normally the invention will belong to the employer. That is normally the position. But often at the early stages, they aren't employees, they're contractors, or they're people that are actually, their relationship is not very well defined. So getting an idea of what IP you have and who owns it, and then taking steps to make sure that the company owns it, saves you a lot of time, effort, and money in the future, particularly when investors get involved. So that's an important thing to consider.
And I think it's one of those things that, you know, if you are a company that is who's in the early stages of a product development, you know, it's one of those things that seems like something that you can all just muddle along without arranging now, but if you start being successful, it suddenly becomes a big issue. So it sounds like one of those jobs that's worth doing early doors to save potential grief in the future.
It's funny how it starts to become an issue when money gets involved. Yeah. And there are things you can do and steps you can take to make those kinds of problems go away. So that's kind of what you've got, and taking steps to protect that and working out what you've got. But it's also important to consider what other people have got, because the concept of freedom to operate, it's perhaps best to think of it as infringement risk. What are the risks with other people's IP that you might be infringing? And doing some kind of investigation into that is a very good idea. You have to come up with a strategy, because it depends on your budget what you can do. Large companies might spend a lot of money looking at all the other patents that might be out there and trying to work out whether their new product would infringe any of them and what the risks are and so on. Small companies often don't have the budget to do that, but some kind of investigation is a good idea. You can do things like looking at your potential competitors, or the people that might be on the market. What do they have? You can look at whether they file patents for their technology, and you can consider whether you might infringe them. You can go beyond that and start doing searching on patent databases for other people's patents, and looking at whether there might be problems out there that would prevent you from using your invention. And again, that's the kind of thing that really you probably need a patent attorney involved in, to be able to advise you on the risks associated with those other rights. And it gives you an idea of sometimes you might find that there are patents out there, but you might find that actually there are ways of designing around those patents, changing your product. The sooner you know about these patents in your product development cycle, the easier it is to make changes to your product to avoid infringing. And it's less costly to do it in the early stages than it is to do it just before or after you've launched.
Yeah, absolutely. And I mentioned earlier a roundtable we did with our members on the subject of IP law. And one of the things that all the SMEs said was that, you know, the line between profitability and not is a very fine one. So if you can take steps like you've suggested to, you know, reduce the chance of future financial shocks because you found to be infringing a patent that you weren't aware of, then that you know, that can be only be a good thing for your profit margins. There's something else I wanted to ask you about, which is actually a bit of a sidestep from what we were talking about just now. But a lot of our members sell their products all over the world. You know, their software is kind of sold without borders anyway, and the guys who make physical products are, you know, successful in selling them in other parts of the world. So how do patents relate to international export?
So yeah, the patent system is territorial. So you get patents in each individual country. Effectively, each country has its own patent office, and they will do their own investigations as to whether they're going to grant a patent. So you have to go through the process in each country. The important things to consider then are what countries are important. You say software, as you say, is sold without borders, and often at the early stages, inventors are interested in global domination and nothing else will do. But from a patent point of view, it'd be very expensive to file patents in every single country. Not even pharmaceutical companies really do that. So you have to consider where your important markets are. For software in particular, it can be made anywhere. What countries are going to be the biggest markets? The answer to that is normally some combination of Europe, the US, and possibly places like China and Japan and Korea and so on. But normally the US and Europe are the two big ones on the hit list. And often that covers a large chunk of global GDP. That's often enough.
And patents in Europe, is the whole of Europe covered by one patent? Do you patent for the EU, or do you have to do individual countries?
That's a very good and very timely question. So Europe, when patent attorneys talk about it, it means slightly different things. The European Union is obviously one thing, and then there's the European Patent Convention, which is another thing. So rather than having to apply in each individual country in Europe, a bunch of countries, including all European Union members, but others as well, got together and formed the European Patent Convention, which is administered by the European Patent Office. And the European Patent Office will grant patents to cover any country within the European Patent Convention. The European Patent Convention has more countries in it than the European Union. For example, the UK is a member, even though we're not in the EU. There are other countries like Switzerland and Iceland who are members of the European Patent Convention, but not in the European Union.
So if you were a UK company looking to patent something, do companies generally just get the European patent because it covers the UK anyway and all the others, or would you generally get your patent in the UK first and then the additional European one?
What you'd normally do is you'd start with one application and you'd file that probably in the UK.
Yeah.
And that plants your flag. That sets your date where your patent will be considered for whether it meets the criteria of patentability. You then have a period of 1 year where you can file in other countries, including at the European Patent Office and at the US Patent Office, for example, or the Chinese Patent Office. And those applications can be backdated to the filing date of your UK application. It's called claiming priority. It's a fancy way for saying that we're going to backdate your later filed applications in other countries back to the filing date of your UK patent application. So what that means is you don't have to incur the expense of filing in all countries that you might be interested in at the start. You can wait. There is actually another way of, there's a further way of deferring that decision as to what countries you want to protect in. It's called filing a PCT or international patent application, which it gives you a way of delaying. But ultimately, you then need to decide what countries you're interested in. If you want protection in Europe, you would generally go to the European Patent Office, and they would examine and grant an application. And you then have to decide which countries within the European Patent Convention you then want protection in. Again, there's 38 odd countries covered. You probably wouldn't protect in all of them. Most people will say, I want the UK, France and Germany because those are the main markets, and I might want some of the other countries as well. Recently, we have seen some developments in what's called the unitary patent. The unitary patent is an option. Instead of, once the European Patent Office grants your patent, instead of going into validating it in each individual country, you can cover some countries as a group with a unitary patent. Those countries are the EU countries. So the EU countries within the European Patent Convention got together and said, we're going to have a single patent that covers all the EU countries. It doesn't cover the UK because we're not in the EU, and it doesn't cover other countries that are not in the EU. It doesn't even cover some countries that are in the EU, but I don't think we'll get into that right now. But the important point is you have options in order to cover it in Europe.
Thank you. That's really useful. Now, I think we'll get on to what is going to be our last question. And it's, I think we've covered a lot in this video, and it's been really, really useful and really interesting. And we've kind of touched on this already, but just as a last takeaway for the people watching this, you know, you want to do something about the patent situation for your business. You want to give yourself that protection that we've talked about. What is the thing that they should go away and do as a priority? What's, you know, what is job 1, 2, and 3 that they can do now and make a real difference?
Yeah, very, very good question. I think number 1 is don't be scared of it. Make it someone's role. Pick someone who is going to be responsible for it, and get an advisor in place that you like and are comfortable with. And the first steps to do after that would be to work out what you've got and get a strategy in place for what you're going to do with it. So have an invention harvesting session, get an IP audit done, find out what IP you have, because that's where a lot of the value in your business will be. And understanding that makes you better armed to make the value case for what's valuable about your company when talking to investors. Number 2 is make sure that you know, and that other people in your organization know, to keep it secret and not to disclose it without having non-disclosure agreements in place. And I think if we're giving the kind of really important things to do is to start with is the ownership question. Make sure that you've worked out if you own it. It's a fundamental question, and it's normally quite easy to solve, but doing it early on avoids many problems later.
Thank you. That's really useful. I'm going to add one to that, if that's okay. Is, you know, speak to people like yourself, you know, do speak to the experts. And you sort of mentioned, don't be intimidated by it. I think, and correct me if I'm misspeaking here, but I think, you know, if a company is concerned about their patents, if they can pick up the phone and have a bit of a chat with you, and it's not going to be a case of having to get the checkbook out when they say hello. You can help steer them in the right direction, help make sure.
We're a friendly bunch of people, and we like to talk to people about their cool technology.
Yeah.
That's what's great about the job. It's a fantastic job because you get to work with really passionate people working on cool technology. What's not to like about that? So yeah, we obviously offer and are happy to give an introductory chat to talk about what you've got and talk about the patent process and how we can help and add value.
Great. And I'm going to add one more point into that, if you don't mind, which is that, you mentioned people being intimidated by the process earlier, and we're talking about approachability as well. And, you and your colleagues are very approachable, and, people can pick up the phone and just have a chat with you about this.
Yeah, absolutely. We're a friendly bunch. Patent attorneys are a friendly bunch of people, and it's it's a brilliant job. We get to work with really passionate, interesting people who are working on cool technology. What's not to like about that? So we're happy to chat, and we obviously offer free introductory calls to or meetings to talk about what you've got and how the patent process will play into that, and how we can help and add value.
Brilliant. Thank you, Pete. Well, I think it's been a really interesting conversation. Definitely has been for me, and I'm sure it has for our members as well. What I'll do is when we post this video, I'll make sure that your contact details are on there as well, so members can get in touch for that conversation. And I'll also link to the funding for the IP audit that you mentioned. But yeah, just as we said, thank you very much for joining us for this video. And if you've got any questions, please contact me or contact Pete.
Thank you very much. Been an absolute pleasure.